Right now, without your knowledge, without a warrant, and without probable cause linking you to any crime, law enforcement may already have your location data. Not because you are a suspect, not because you did anything wrong, simply because your phone was in the wrong place at the wrong time. This is geofencing, and it is one of the most serious constitutional threats facing ordinary Americans today. Geofencing warrants, also called reverse location warrants, allow law enforcement to demand from tech giants like Google, Apple, and major cell carriers the identity of every device that entered a defined geographic area during a specific time window. A protest, a mosque, a political rally, a neighborhood, draw the digital fence, demand the data, and suddenly hundreds or thousands of innocent people become persons of interest in a criminal investigation they knew nothing about. Geofencing is the use of GPS, cell tower data, or Wi-Fi signals to create a virtual geographic boundary. When a device crosses that boundary, the system logs it. Law enforcement can then demand from Google, Apple, or any carrier, who was here. Your phone does not need to have an app open. You do not need to be connected to Wi-Fi. In many cases, all you need to do is carry your phone. As a paralegal and private investigator, I have spent years working inside the legal system. I have seen how evidence is gathered, how warrants are written, and how the law is stretched beyond its constitutional limits. Geofencing warrants represent exactly that kind of stretch, and the courts are only beginning to catch up. The Fourth Amendment to the United States Constitution is unambiguous. It guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. No warrant shall issue without probable cause, particularly describing the place to be searched and the persons or things to be seized. Geofencing warrants violate every one of those principles. They are not particular. They do not describe specific persons. They are dragnet searches. Cast wide, pull everyone in, sort out the innocent later. In 2018, the United States Supreme Court ruled in Carpenter v. United States that obtaining 7 or more days of cell site location data without a warrant violated the Fourth Amendment. The court recognized what many of us already knew, that in the digital age, location data is intimate data. It reveals where you worship, who you associate with, what medical care you seek, and what political beliefs you hold. But here is what Carpenter did not resolve. Geofencing warrants go far beyond 7 days of one person's data. They demand the data of every person in an area, for any length of time law enforcement chooses to define, with no individualized suspicion whatsoever. In Austin, Texas, a geofence warrant targeting a violent protest returned data on over 1,500 devices. Innocent people, journalists, bystanders, residents, were swept into a criminal investigation with no probable cause connecting them to any crime. Courts across the country are currently divided on whether these warrants pass constitutional muster. Some have struck them down entirely. Others have allowed them with modifications. The legal landscape is unsettled, and that uncertainty is dangerous for every American who carries a smartphone. You have rights. The Fourth Amendment still stands, but rights without awareness are rights without protection. On Words with Wentz, we do not just explain the law, we put it in your hands. Because an informed citizen is the government's most powerful check, and right now more than ever that check is needed. This is Words with Wentz. Know your rights.